Hold on, if it'll let me.
And while she's sharing her screen, I also want to encourage you all to RSVP for the other topics in the session. So it's from, financial planning. Obviously, today's topic is estate planning. And while she's sharing her screen, real estate investing. So there are multiple topics that you can RSVP for as part of our education series. Okay.
So oh, sorry, go ahead.
No, you go.
Okay. So I'm basically I'm going to assume that most of the people that are viewing today do not know much about estate planning. So what I do is an estate planning 101 series where I really explain the basics so that we can all start from the same place. First and foremost, we have some very common misconceptions about estate planning that I want to refute before we even go any further. Number one misconception is that estate planning is only for rich people. And the second misconception is that estate planning is only for old people, or we might call them mature people. And nothing can be further from the truth. So I think it's important to first of all explain what is estate planning. And then you'll understand why it's something that we all need. Estate planning is, in a nutshell, in lay people's terms, it's planning today, so coming up to date with your plans for how you want your affairs to be handled and your assets to be distributed if you become incapacitated or once you pass away. And that's why it's so important for everyone to get into and create their estate plan early. It's never too early to create your estate plan, and it's not something that's set in stone. You can always change it down the road, and I actually always recommend that people review their estate plan at least once a year. Typically, I say do it during tax time because tax time comes every year, and so it's an easy reminder to also just double check your estate plan. The purpose of estate planning is you will allow yourself to have a huge say in what is going to happen with all of your assets that you've amassed during your life. And you're going to determine who is going to receive what and when they're going to receive it. You're also going to be able to minimize conflict between family, which is a huge reason for estate planning. Unfortunately, when people pass away, you tend to have the worst of people coming out. It's really unfortunate, but it's realistic and it does happen. So if you have your estate plan and your affairs are already in order, you won't have the fighting and the conflict among your loved ones about who's supposed to get what, because Aunt May always said, I was going to get this. It's in writing. You know exactly what Aunt May wants everyone to have. And it also provides for an inventory. You don't realize how much stuff you have until you sit down and start thinking about who you want to leave which items to. So what happens if you don't take the time to create an estate plan? Well, first and foremost, a judge is going to make a lot of decisions for you because you haven't done so. And this can be as basic as who is going to get the house, but it can be as important as who is going to take over guardianship of your child, whether it's a minor child or a disabled child, which is extremely important. And again, if you don't have your estate plan taken care of, then because you have a third party, a judge making these decisions, the result can end up being a person that you don't know or would never have wanted to be in charge of your estate or your child. That person could very well become the individual who's appointed. And of course, if you don't have a will, which we'll get into a little bit later, the legislatures of every state have an estate plan already for you. And I will go through what happens if you don't have a will. I have a whole video on that. Again, same thing, just like your children can end up with people that you wouldn't have wanted them with, your assets can also end up with people that you didn't want them with, but they can also receive it before you would have preferred they receive it, which really comes in when you're talking about children. Sometimes you may have a child that you just know, okay, they're not the most responsible, they're not really mature yet. I would prefer to have them receive their inheritance later on in life, give them, more time to mature. Well, if you don't set up your plan in advance, that stopgap is not going to be there. That protection that you would have wanted is not going to exist. And that's the assets being distributed to your children before they're ready. And you've also given up the opportunity to save on taxes and potentially protect your assets. And like I said, family disputes. So these are the kind of documents that you would have in an estate plan. Not everyone's estate plan will include all of these, but I've thrown in pretty much your basics of estate plan document tools. So will, also known as a last will and testament, and I will go into more detail about each of these documents. So for now, I'm just going to outline and list them. You can have a revocable trust or a living trust, a durable power of attorney, a living will, which is different from a will, also known as a last will and testament. And that's very important. A lot of people get them confused or think they're the same thing. They're completely different documents. A healthcare surrogate designation, a statement of disposition of tangible personal property, and this can be used in either a will or in a trust. You might have to retitle some of the assets that you own. Beneficiary designations, meaning who gets what. Guardianship designations, and that deals with who's going to take care of the children. And life insurance is also a great and very important tool in the estate planning. I do know that Pettis and Dawkins will be speaking further on, I think, during this week. And if you have time, I highly recommend that you stay tuned for that, because they are phenomenal and they know like life insurance inside and out. So we'll start with the will. And in summary, a will is an instrument that directs how your assets are going to be distributed, and how your debts, your taxes, your expenses are going to be paid after you pass away, because believe it or not, you still have to pay some of your debts when you pass away. When you create your will, you're going to identify certain people. You're going to identify a personal representative, who is the person who is going to be responsible for carrying out the directives of the will. So they're the ones that are going to be paying those bills. They're the ones that are going to be cutting checks. If assets, let's say your home is going to be given to a particular person, the personal representative is actually going to be the person that's going to sign that deed. And you'll name any guardians of minors or incapacitated children that you may have. You're also going to name beneficiaries, and beneficiaries are the individuals who are going to be taking title or ownership of whatever it is you're leaving behind for them. And you might have a testamentary trust. What testamentary means is it's in the will. So you can actually create a trust through your will. And what happens if you don't have a will? There's a lot of things that won't happen. You're not going to have named beneficiaries. You will not have a named guardian that you have pre-selected. You will not have a personal representative that you have selected. You will not have, because it's not possible to have a testamentary trust without a will, because they are created by the will. And all of this matters because if you don't do it, the legislature or a judge will make all of these decisions for you. I actually have a video that goes through the Florida statute on intestate succession, which is the law that controls if you pass away without a will. It's pretty quick. I hope you can see it, and please let me know if you can't hear it.
The audio's not playing. No, it's not playing yet.
Okay, so you know what? I'm not even going to try and play with that.
Just,
I will make this video. What I'll do is at the end, I will actually post the link to the video in the chat so that you guys can watch it, because I actually go through the entire statute and it's a lot of nuance. So I'm not going to try and wing it right here because I don't have the statute right in front of me. Well, in short,
let's play it at the end then. We can figure out somebody made some suggestions, so we can figure out the sounds. But we want to make sure we play it at the end. I have some questions that are coming up, if you don't mind. So Josh, you can
we can stop here
as well. Okay, Josh?
I'm here.
Okay. So first question from Milo. Why do some people put their homes in trusts or LLCs?
So it could be a couple of different reasons. One of the reasons why people put homes in LLCs is so that you can limit liability from each property. Like if it's not your primary property, especially, you may put it in an LLC so that if something happens on one property, you're not responsible. They can't go after you for the other properties or go after you personally for any lawsuits or anything like that that may arise from the whatever it is that they're going after you for. So the LLC is like its own like person. It's not a person, but it's its own entity, and it keeps each property from having liability for the other ones.
Okay. So what about trust? Why would someone put their house in a trust?
So it's from what if I'm understanding him correctly, I mean, you would put your home in the trust so that you don't necessarily have to go through the probate process
Right.
that's being described right now. So anything that's in a trust it avoids probate. So it's basically like eventually I think she was gonna get to it in her presentation, but a revocable living trust is basically like a contract that you have with your where you designate who you want to be the trustees. Usually when you're alive, it's you or your spouse, and then who you want to be the trustee after you die. Similarly, you have beneficiaries who are going to inherit the things that are in the trust, but the things are in the name of the trust because that also is sort of a way to limit liability and some of the tax burdens that go along with it. So,
Right. Okay. And then, Alecia, feel free to also add as well so that it can be interactive because the
Sure.
questions are starting to come in. So, is it expensive to obtain an estate plan? And obviously, people see these commercials from LegalZoom, and it's like $100 will, or they see these Facebook ads by no-name attorneys, and they charge $3.99 to go get an estate plan done. So, what's the right and the wrong way? And what type of average cost can someone expect? And are there different levels? So like if you have this many assets, then you can expect to cost this much, or if you need something this complicated, or if you just need something simple, then kind of budget that much for it.
So I can talk about LegalZoom all day. Estate plan, the price, the cost, it does depend on the individual circumstances because like you mentioned, some people may not need a more intensive estate plan. So if you're talking about a simple estate plan where you're just gonna have the three things that I recommend everyone has at a minimum, which is a will, a living will, and a power of attorney, that could run you $1,000 to $2,000. Then you get into trust, which it's going to cost a little bit more, and you might have sub trust. So it depends on the individual estate and the needs of the estate. Now, I don't ever believe in do-it-yourself lawyering. Believe it or not, you may spend $100 today, but if it's not done properly, what's going to happen is when you pass away, that's when we'll find out that it wasn't done properly. And you're going to end up spending more money. Well, your estate will spend more money trying to fix it. I have two examples of how do-it-yourself lawyering can go really badly. One was apparently Susie Orman has do-it-yourself packages, and an individual decided to use a trust from one of those packages, and they actually left all of their assets to a Susie Orman trust. That cost them about $16,000 in probate to fix. And then I have another situation where someone decided to, it was a mother and a daughter, and they decided to sign a will, a deed, and record it with public records. They assumed that the way they were doing it, the mom would own until she passes away. And then once the mom passes away, that property would go directly to the daughter. But because they didn't have the right language, that's not what happened. Instead, an entire probate has to be opened just to deal with the mom's ownership of that home. And as a result, because mom didn't have a will, we now have 5 additional owners of that home when in reality, it's only supposed to have 2. So now there are 7 owners of a home that should only have 2 owners. And that's what do-it-yourself lawyering can do. If you don't know how to prepare these documents, it's really difficult to fill them out and also to tweak them so that they are relevant to your specific situation and your goals.
Okay, so another question for the both of you. So Josh, Um, let's just assume that someone has not heard these terms before. In like simple layman's term, probate. Can you explain probate to us, and even the parts of probate that can get very nasty and why people want to avoid probate?
Okay, so probate essentially is when someone dies, if they have a will or they don't have a will, you have to go through a process called probate, which is when a court determines who is going to get what, who's going to inherit what. And um, like the video was going to explain, if you don't have anything, there's a pretty standard formula that's going to dictate who's going to get what. And if you have a will, then it's pretty clear cut most of the time, but sometimes when you have a will and you have to go through probate, people can contest the will and say that it's not the most recent will, that the person didn't have the the mental ability to make a will. They were coerced or tricked by the person who is getting all the stuff, and then that could also in itself lead to more costs. So something that you did it on your own, or you didn't necessarily have all the information, and you got it for you figured it out for free, or what you think is free because your time's not free. So either that, or you paid $200 or $300 to a non-attorney, or some bought a $20 book, or whatever the case is. It could potentially cost you your whole inheritance, because if you don't have the money, you're gonna have to figure out a way to spend. You're gonna spend more money than you could potentially inherit. So that's more or less what probate is. And then
Okay, so while we have, oh, sorry.
I was asking you, was there a second part to the question?
Yeah. So while we have this guardian screen, yeah. So the second part is going to be revocable living trust, since you mentioned it. But while we have this guardian screen, right? Let's talk about parenting, because parents may think, okay, I'm married, so if I pass, my child will naturally go to my spouse, or say if I'm not married, the child will go to their birth parent. How complicated can the parent the how kids are cared for after the fact if you don't have this spelled out? And that's for either of you.
It can be pretty complicated. So first of all, it's important that everyone knows that godparents do not have any legal rights. So let's start from that, because a lot of people are under this misconception that because so-and-so is the godparent, if I pass away, they will become the guardian of my child. That's not the way the law works. If you pass away, your child, if the other parent is alive, yes, they have if you do a priority of who's entitled to guardian, it would be the biological parent first. But what happens if you both pass away? Or what happens if the surviving parent is not capable of taking over and stepping in and becoming the sole parent? The only way to guarantee, or have a very strong guarantee, that the person you would have preferred take over guardianship is to include that provision in your estate planning. It can get difficult. You're talking about litigation. You may even have DCF involved. You don't want that. And it's just like people are fighting over money and people fight over property. They will fight over children, especially if there's money involved with respect to the children and their care. If sometimes people do leave inheritances behind for their children, well, who's going to be in charge of overseeing that money until the child reaches a certain age? The guardian, unless you've spelled out, in a trust, for example, who is going to be responsible for the money, who is going to be responsible for the child. So it can be really bad.
Is that also the case for a parent who has sole custody and they pass on, and the non-custodial parent, would they automatically would they receive the child, or, and I'm not terming it right?
So the way the law is the law wants to do what's in the best interest of the child, and generally being with your biological parent is what you would think is in the best interest, unless there's some reason why we can say it's not. And so that would be where you start. And as she was saying, if the biological parent was unable or unwilling, then you would look to the next best person and if you don't have a document in place, they may look to another relative or an aunt, a grandmother, an uncle or something like that. But also, while we're talking about guardians, it's not just about children who may need a guardian. So if something were to happen to an adult, you as the person who's creating the estate plan, you may one day also need a guardian. You may have a catastrophic car accident where you're left brain dead, and you have to have someone who's going to be in charge of your affairs. So it's not just a plan for after you die necessarily, it's also a plan for while you're living.
True. Okay, so I created a living trust after, right when the pandemic hit, right? When you saw all these people dying, that's like the first thing that comes to mind. Let me get all of my stuff in order, right? And I think right now with how grim last year was, people were like thinking of these things again. So within my trust, I have a will, right, for anything that's outside of the trust. Can you talk about the process? Because that goes back to the question earlier, the part 2 of why do some people put their homes in trust? So as I understood it, when I created my trust, whatever is not deeded over to my trust gets in the pour over will. So you want to make sure that you transfer everything into your trust during your lifetime. The will would take care of whatever's not in the trust, but you also don't want the will to have to be dealt with in probate court. So can you go back to that question in terms of, how trusts are managed and the difference between a will and a trust, and why one supersedes the other, and the power and the authority that one has over the other?
Okay. I wouldn't say that one supersedes the other. Not everyone needs a trust, but everyone should have a will. So let's again talk about what a trust is, because Josh did explain it earlier, but it's important that people understand that a trust is a legal document that allows a third party, who is called a trustee, to manage, hold, and have control over assets that are in a trust fund for the benefit of the named beneficiaries. Some of the benefits of trusts are you do avoid probate for any property that is placed into the trust. That is a key component of having a trust. It's not enough to just have a trust. Number one thing that people forget to do is to fund the trust, which means putting assets into the trust. I always tell my clients, think of a trust as a box. The paper trust document is a box. If nothing's in that trust, nothing's going to be given out to beneficiaries pursuant to the trust. The reason why you have, like Fabiola mentioned, a pour over will is because inevitably you're not going to get around to putting every single thing in that trust. That's just the way it is. And so you have a backup. Okay, we never got around to putting this in there. That's okay. The will says it goes to so-and-so. A will is only for the purpose of probate, whereas a trust, anything that's in the trust transfers outside of probate. It's going to transfer pursuant to the trust instructions. I still recommend that you open a probate if someone passes away with a trust for the sole purpose of ending the clock for the creditors. In Florida, creditors have 2 years after someone's passed away. You can stop that 2 years and turn it into 90 days by simply opening a probate and doing your publication for your creditors, and 90 days is the cutoff. So I like to still do it, file a notice of trust with the probate court. But the difference is, in that instance, the assets are still going to be transferred pursuant to the trust. So you're not waiting out the entire process of the fighting and the whatnot through probate. You're just filing the probate for the purpose of notice and to cut off that timeline for the creditor period. One thing that a revocable trust does not do, and this is extremely important, because when you're talking about long-term care, for example, nursing home care, a revocable trust does not in any way protect against long-term care. You hear a lot about people who have to sell everything. They have to sell the houses that they've amassed because they need to go into nursing homes, and they did not plan that in advance, but they need Medicaid to make payments for the nursing home. And so Medicaid, you can't have all of these assets and still collect Medicaid. There is an irrevocable trust that can be created for the purpose of, it's called elder law, so long-term care planning. That is different from a revocable trust. I think that covered the questions that they had, that people had already asked about trust specifically, but let me know if I missed anything.
And also to just clarify on that just a little bit, it's in the name revocable, irrevocable, but if it's revocable, that means that you can take the money out, you can do other things with it, but once you put it in a irrevocable trust, that's it, it's in there. So I mean, that's one of the differences, and there's reasons why you would want to do that, for for estate tax reasons, or for special needs if you have a need for Medicaid or something like that as well. So I just wanted to make that clarification because it wasn't stated that like that. So I just want to make sure everybody understood.
Yeah, that's a very, very important point. Yes.
So let's talk about some myths, right? And bust some myths. So it could be like you mentioned, you don't have to be rich, right? But then the other myth could be, I don't own a home, I don't own real estate, I don't need any of this, or I'm young. Death is still a long ways away, so I don't need to start planning for any of that. And I know that in my trust, it even talks about how I want my funeral and my burial to be. So let's, kind of talk about some of those myths about age and asset ownership, and still how important it is, regardless if, you don't have some of these things in place.
Right. So I feel like after COVID, I should never hear someone say I'm too young to do my estate plan. Because as we just learned, tomorrow is totally not guaranteed. You don't know what's going to happen and how long you'll be here for. Josh mentioned earlier that one thing that can happen is you can be alive but incapacitated. And so in that instance, who's going to be in charge of your financial affairs? Who's going to be in charge of your medical affairs? That's where a living will and a power of attorney come into place. And those are like the key things that a lot of people don't realize are a part of estate planning. Estate planning is not just for after you've passed away. It's also for what if you were just not able to make your own decisions or, take care of yourself at some point. If you've done your estate plan, you will have already considered that and have a plan in place for those eventualities, because it can happen.
And just think about it, even for all these graduating seniors going off to college, even if it's not catastrophic or you're brain dead, but if you're in the hospital and you're over 18 and your parents are trying to get information, they're not going to be able to necessarily get the information that they need to get if you don't have that power of attorney or whatnot. So like, I agree 100%. A living will and a power of attorney is something that everyone should have, period. Like, it's not even close. Like, without having those documents, you're leaving yourself at risk for bad things to happen. I mean, no other way to put it. So, and those documents are not expensive. I would definitely reach out to an attorney to have someone draft them. I personally like to work with people like, and do things kind of like, I don't have a nonprofit law firm, but I do have like income-based payment plans and different things like that. So that, and other attorneys I know do too. So it's not something that you should just put off because you think the money is the issue. Like, money shouldn't be what keeps you from protecting yourself, protecting your family, and making sure that everything is gonna, move on the way that you want it to when you're unable to make decisions because you're incapacitated or because you're no longer here.
Josh, that was the most practical but best example that you could give, right? Because you would think someone who's 20, 21, they're an adult, they're on their own, but what if they don't have a spouse that would be next, of kin for them? And so the parent legally can't, manage certain affairs for them. But that was a great example that you just gave, because I can almost imagine, a parent in that situation who is trying to help out their child or get some information about their child who may be in the hospital, but hospitals won't release that because you don't have power of attorney or you haven't been named as, next of kin or anything like that.
Right. It's not that they won't, they cannot.
They cannot. Yeah.
Yeah.
They're not supposed to. So you might get lucky and somebody feel bad for you and they just kind of tell you some stuff, but legally there's federal laws in place that prohibit them from giving you information. So.
Right.
Okay.
Are there any other questions?
I saw a question. If my family and friends know I have them in my estate plan, what legal clauses are there to make sure they don't take me out to reap the benefits sooner? This question is from someone who watches a lot of Dateline and
Snapped and
exactly.
I mean, there are no legal protections to keep someone from causing you harm other than the criminal law, right? I don't share who my beneficiaries are. There's no reason for you to tell anyone what's in your estate plan. It's not, there's no requirement that they know. The only thing that I do recommend is that you speak with whomever you're going to be nominating as guardians of your children, because you want to make sure that this is a person that wants that kind of responsibility. But other than that, you're not required to let anyone know who's getting what in your estate plan.
Let them find out after you pass.
Yes. Yes.
Okay. Oh, the other part to the question, what if someone doesn't own their home, or doesn't have any assets per se? Can you still, I don't want to say convince, but show us still the importance of doing this, even if you don't have any assets yet?
Well,
So
you're hopefully planning on getting assets, right? You're planning on accumulating assets over your lifetime. So it doesn't hurt to go ahead and do it if you're talking about it from the perspective of just assets. But as we stated, there's more to estate planning than just dealing with assets. There's also who's taking care of you, who's making decisions over you.
Okay.
That's very important. I think that's more important than who's taking assets after you pass away, honestly.
So you don't need to have a house in order for you to start thinking about your plans.
Correct. That is correct. I had my first will done when I was still in law school. I didn't own anything but a car worth like $3,000. Absolutely.
and I can also
Because
kind of give, go ahead.
Go
I'm
ahead.
sorry.
No, go on. Go ahead.
Well, no, I was just gonna say, like, it's important that you know, because if you have it written down, because if people don't know, people may do things that are just against your wishes. So, like, I know for a fact, I spoke to my grandfather, and he is afraid of being cremated after death, even though, you know, you can't feel it, but he doesn't want that. But if we didn't know that, somebody could say, well, it's cheaper, let's just get the cremation, or whatever the case is. But he made it known that that's not what he wants. So for him to take the steps to make sure that doesn't happen. So it's just stuff like that. Anything that you want to have, you know, the only way that you can make sure that your wishes, the best way that you can try to make sure that your wishes are you know, are listened to, is by putting it in writing so that it's documented. You know, people may still try to do things or do stuff, but you got to take whatever actions you can for yourself to try to eliminate that.
Yeah.
Before we move on to trustees, and there's a question about that. Josh, you mentioning your grandfather, you know, brings to mind our parents, our elderly family members, our grandparents who are still alive, our parents who may not have a will or anything else. And we hear about celebrity deaths, and they occur and they don't have anything in place. So, you know, if you're if you have an elderly parent or a grandparent, what should we start doing to get their affairs in order, so that, you know, in the event when they do pass, we don't have to deal with who's getting what and whose house does grandma, you know, go to, or anything like that?
I mean, the most important thing is having them sit down with an estate planning lawyer, having the people who are going to be helping to make those decisions, if anyone, you know, guide them through that process. But also another thing, when you brought grandparents back up, that it made me think about, was kind of like the bootleg estate plans, where you put the property in the name of the person who you want to have it, because, you know, they're younger than you, they should live longer than you. Well, my grandfather did that, and he's still alive. My dad is not. So, you know, when that happens, that creates issues. And then once you put stuff in people's names, it's easier to put their name on than it is to get it off. So you lose control of your stuff, even if the person doesn't die before you die. That's one of the other things to also consider about, you know, trying to go around the estate planning process, which it seems like is kind of prevalent in our community.
So let's, at the end, let's talk about some of these bootleg practices to look out for, because you mentioned earlier, Alecia, about do it yourself, and, you know, making the mistake of opening up one of these $20 books and doing your own planning. And then Josh, you just mentioned when people write it in the name of someone else, assuming that that person will live on past you. So there are probably a lot of very simple, common mistakes that people make that they don't realize could be can affect them in the future as well. So we can get back to that. Someone does have a question since we have this up on trustees. The question is there an issue with making a beneficiary the trustee of your estate plan, or should this be kept separate?
So let me go down the list of who you can name as trustees, because that's in here. You can name yourself as a trustee, family members, friends, professionals. There are attorneys that will serve as trustees. I do not do it because to me it's a conflict. There are actual companies out there, institutions that serve in that capacity. And you can in fact name beneficiaries as trustees. Just be mindful of the fact that one of the reasons why you're creating a trust may very well be because you want to protect your son from themselves. And if that's the case, it probably wouldn't be too wise to also name that son as the trustee. So you just have to use, your best sense when you're doing this. But yes, you certainly can name a beneficiary as a trustee.
We've been kind of hopping around a lot, but when you talk about a trust, one of the things that kind of what she's alluding to is when you have a trust, you also kind of have control even after you die. So if you have 3 kids, let's say, you might say that one can get all the money right away because you know that he or she is responsible and they're going to take care of their money. And you might say another one can get a third when they turn 25, a third when they turn 35, and then the rest when they turn 50. And you might have another kid who you say, in order for them to get their inheritance, they have to have a prenuptial agreement with before they get married, so that they don't lose the money to their spouse, because you know that they're that kid who's always in love and it's the real thing and whatever, and they can lose their inheritance to a spouse who maybe was only there because they knew they were going to get that money. So that's one of the other things about a trust, is that you kind of have control and you can put things in place and set limitations. Or if you die before your kids are adults, then you can't really leave money to kids in a way where they can use it. So you kind of can have everything in place so the trustee can take care of the kids and give the money to the guardians as needed. So.
And again, we don't want to give the impression that you have to be rich, because this can be 401ks, life insurance,
Right.
Other forms of assets as well.
Yeah, we'll hear. I'm sure we'll hear about that later on in the week. But the life insurance is something that everyone should have. So even if all you have is just that $100,000 policy, or $250,000 policy, $30,000 policy, if you have a policy that large, your child is going to have a guardian. So if you don't have a trust, you're going to go through probate, and if you don't have a guardian listed in your will, then the court is going to say that you have to get a guardian. You may have to pay for that guardian. So there's a lot of reasons why not having your affairs in order can cause big problems later on. So.
Okay, I think that's all the questions for now.
Okay. Guardians as trustees. Sorry, I didn't click through. And then as far as who your beneficiaries are or can be, it's pretty much the sky's the limit. You can name your children, you can name charities, other family members. I didn't include in that also just friends and, loved ones, significant other that you may not be married to, that you can leave assets to them in your trust as well. And as we were talking earlier about the irrevocable trust, I think I already talked about, I talked about funding and how important it is to fund your trust. Just having a trust is not enough. You actually have to fund it. And you can fund it. We mentioned life insurance. You can actually name the trust as the beneficiary. And you can also transfer property into it. You can assign interest, so stock. Pretty much the sky's the limit as far as what you can put into your revocable trust. But it's important that you do that, take that step. And we talked about the pour over will earlier.
Yeah.
And then, Josh, did you have anything else to add on that one?
No.
Okay. So then we can get into the power of attorney, which deals specifically with your finances. And this is who is going to be in charge of your financial situation, your financial matters, if you are incapable of doing so. Let's think about COVID in the last year. So many people were in the hospital and placed on ventilators, and they just were not able to make their own financial decisions just because they physically could not do it. They were incapable of doing so. If you don't have a power of attorney, no one else can do it for you without the court intervening and allowing someone, giving someone temporary guardianship if it's a temporary situation. So rather than adding money, because going to court for guardianship is not inexpensive, and it also takes time, right?
Yeah.
So if you have the POA, you don't need to go through all of that delay and expense.
Every time she says court, just say more money. Like, remember that in the Living Color skit, more money, more money,
Yep.
more money. It's all going to cost you money. You got to pay the court. You're going to have to pay for the court fees. You have to pay for an attorney. It's going to take a long time because nothing happens fast in court. So, I mean, just think about that. Every time you hear court, think money. So the more you can eliminate having to go to court, the better it's going to be.
Right.
Because probate can take years, right?
Yeah, it can. Yeah.
It shouldn't.
It's not supposed to. In
shouldn't.
Florida, it's supposed to be 1 year. Unless you have to pay estate taxes, then you're going to go over a year, but 1.5 years is pretty much what's expected. Anything beyond that, you have to explain to the judge why it's taking so long. And if it takes that long, it's because there's litigation involved. If everyone's not fighting, if it's a pretty straightforward, it should take 1 year.
Got it.
And that's for, just to be clear, that's for formal administration. We do have, if someone passes away and they only own their home, just their primary residence, then you would file a summary administration. You're in and out. It's super quick. It's not the same as a formal. With a formal, at a minimum, you have to wait 90 days because that's the creditor period. So at a minimum, you're going to be in there for 3 months before checks can be cut and people are paid out. But,
so
yeah.
You're saying that if it's your primary home, it bypasses some of the typical probate procedures.
If that's all you have, if your primary residence and it's the homestead, then yes, you can do a summary. It's called summary administration. And then there's also the financial cap. So maybe you don't have a home, but you happen to have $20,000 in a bank account, and you didn't have a pay on death beneficiary on your bank account. By the way, that is something you can do with your bank accounts to avoid probate. You can go to the bank, fill out a form. They usually have a form, and you designate a person who would receive the money in that account if you pass away. So let's say you have a bank account, you don't have that, you didn't do a payable on death, and it's not in a trust, right? As the beneficiary on your payable on death beneficiary for that account, but it's only $20,000. You can file a summary administration. It's in and out pretty quickly, like 30 days, maybe 60 days for a summary administration.
So thanks for also mentioning bank accounts, because that's something so simple that I don't think people are aware of that they can really do.
Yeah, most people don't realize that. And that's actually one of the first things I talk about when I do my estate planning consultations. I just tell whether you're my client or my prospective client, go ahead and just do that, because it really, really, really saves a lot of time, because a lot of people will, once they pass away, they might only have bank accounts as assets. So it's easier, payable on death. All they need is a death certificate.
Okay.
All right. So that takes care of the durable power of attorney. And then the other document is a living will, which again, this is if you are incapacitated. So you cannot make your medical decisions for your own behalf, on your own behalf. So in a living will, you will state in advance how you feel about life prolonging procedures. Do you want them provided, withheld, withdrawn? I always go back to this case. It happened in Florida, so a lot of people are familiar with it. It was the Terry Schiavo case, because a lot of people think, oh, I'm married, I don't need a living will because my spouse is going to be able to make the decisions and my spouse knows what I want, so I don't need to put it in writing. Terry Schiavo was 26 years old when she went into cardiac arrest. She was married and her parents were also alive. She was in a coma after the cardiac arrest event, and she was in a coma for 6 years before her husband decided to remove her feeding tube. Her parents objected and said she would have wanted to stay in that vegetative state that she was in. That case ended up being litigated from 1998 to 2005. They had 14 different appeals, 4 attempts at going into the Supreme Court. Governor Jeb Bush weighed in, Congress weighed in, and the argument, the whole question was, would she have wanted to remain in this state? If she had a living will, we would have actually known what she would have wanted. She didn't have a living will. So I always use that as an example of why a lot of people just think, oh, my spouse knows, or oh, my mother knows. That's not enough. It can still end up in litigation. And like Josh said, that means money, 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 and also time, time, time.
And it also takes the pressure off of, I'm sorry, I was gonna say, it also takes the pressure off of your spouse or your parent to have to make that decision, because that's a heavy decision to have to make on somebody else's behalf, whether to let them stay in that state because that's not a good way to be, or to take them off of life support. So either way, that's something that you don't want to have to put that pressure or burden on your loved ones.
That's, yeah, very true. And then the other thing you can do, I actually combine the healthcare surrogate designation with my living will, and I just do it as one document because it's health related and I don't see a reason to have extra documents. I know lawyers like paper. I don't see a point. And what a healthcare surrogate is a person that you actually appoint to make the decisions concerning your healthcare if you are unable to do so. Most of us are familiar with something similar because when you go to the doctor, you normally fill out a HIPAA form where you are able to say, yes, if something happens to me, you, doctor, can speak with this individual. So it's very similar to that, except it goes across the board. It applies to all of your physicians if you are unable to make those decisions and tell them who you want them to speak with and who's going to make those decisions. And we talked about beneficiaries before. I don't have it in here, but yes, like I said before, if you have bank accounts, go ahead and add that payable on death beneficiary. Remember to update your life insurance policy beneficiaries. Remember to update your retirement plans with your beneficiaries, because you may decide that this person, you don't want this person to be a beneficiary anymore. Or what happens if the person you had named as a beneficiary passes away before you? You want to be mindful of who your beneficiaries are at all times. Children can be beneficiaries, but just remember they can't actually inherit until they turn 18. Minors can't. And trusts work really well as life insurance beneficiaries. I do not recommend that you name a trust as a beneficiary of your retirement plan, because this can create immediate tax consequences. And one of the reasons why we have retirement plans is to delay taxes, right? So that's something I never recommend that people do. When you're dealing with your retirement plans, do not name a trust as the beneficiary.
Okay, so with that said, sorry, Josh, can you just clarify that, because those two last points look like the reverse of each other. So the last one says don't name the trust as the beneficiary, but the one prior to that,
retirement plan.
For retirement plan. Oh,
yes.
Life insurance versus retirement planning. Okay, so
yes, that's the difference.
Yeah.
Yes.
I was going to also just kind of say it just so, because people don't know, but I remember my dad got his will done. This is even before I was an attorney. And in the will, the attorney who drafted it said how he wanted his life insurance policy to be devised, which you don't do. That's not something that you would put in a will anyway. So it was not a estate planning lawyer. So that's one of the bootleg things that I was going to talk about. Even if it's a lawyer, it could still be a bootleg situation. But his actual life insurance policy said something different. So the will was done in an attempt to override the life insurance policy, but the life insurance company is not going to look at that, because life insurance is a contract. So they're just going to say whatever you told us is what we want, and whatever that will says, that don't have nothing to do with us. So it's very important that you are dealing with professionals, because even that was an attorney who made that mistake. That was not, somebody, he didn't do that on his own with a form. He didn't do that with a tax preparer or a CPA who thinks they know how to do estate planning on the legal side. He did that with a lawyer. So I just want to throw that out there. So if you have a will right now and it has your life insurance in it, that's not valid.
Okay, so in that situation, the attorney's final statement or position is what takes precedent, and not all attorneys do life insurance, estate planning or living trust. So, pretty much that's what you're saying.
Right. Let me just correct what you just said. What he was saying is the life insurance policy is what controls, not what the will says when it talks to life insurance. Right. And it's because like Josh mentioned, it's a contract. So assets that are in a life insurance policy or a 401k or an IRA are going to transfer to the beneficiary by virtue of the contract. They're not going to go through probate, which means your will has nothing to do with those. The only time your will is going to have anything to do with that is if you didn't leave a beneficiary. Sometimes people do that. They don't designate a beneficiary. Well, if you don't, then it has to go pursuant to your will, because that's the only way to transfer those assets to someone. And if you don't have a will, then it's going to be intestate succession, which means the way the statute says, the way the Florida legislature had said it's going to be distributed. So always have a beneficiary. I can't think of any reason not to have a beneficiary.
Even if it's a charity or something, you got to have a beneficiary.
Yeah. Okay. Any questions in the chat?
No, everyone's just saying that this was valuable information.
Good. I'm happy to hear that. So one of the other things you might have to do with estate planning is retitling assets. Deeds are super important in estate planning. One of the things that you can do if you want to try and avoid probate is you can have what's called a life estate deed, where, let's use me for an example. Let's say I want to leave my home to my brother after I pass away, or my children after I pass away, and I want to avoid probate. So there's actually a deed for that, where I own the home and I have the right to occupy that home for my life. And then upon my passing, it transfers to the individuals that I have named. And those individuals are called remaindermen because they hold a remainder interest in the property. So that situation that I had mentioned earlier with a do-it-yourself deed, they were trying to do a life estate deed, but they didn't properly do it. And as a result, it ended up where they both owned 50% of the property, and it passes down 50% down mom's estate and 50% down the daughter's estate because they didn't have the right language. And you might also have to assign certain things. We were talking about LLCs before. You can assign an LLC into your trust, which people do all the time. You can assign stocks into trust. There's all kinds of good things. If you have jewelry that you want to specifically assign, you can actually do a whole memo where you itemize the specific assets and you would assign those assets into the trust. So those are some of the things that you might have to do with estate planning. I do see the deeds pretty often. And also, in addition to having a life estate deed where you have an individual as the remainder, you can also go ahead and transfer the real estate into a trust now. A lot of people do that as well. And then we already touched on minor children, appointing guardians. And I should also add, because I think we did mention it earlier, this also deals with disabled children, estate planning. If you have a disabled child and you want to make sure that they are cared for, but you also want to make sure that you're not impacting negatively their right to government assistance, or even causing them to lose any government assistance that they may have already, you would need a special needs trust, which allows them to benefit from whatever it is you're leaving, their inheritance that you're leaving, so they'll be able to receive money, so for their care, for their education. I've seen actually people make sure that there's money in this set aside so that their child is able to see a specific aunt or a family member that they're really, really attached to. And so they set money aside just to coordinate meeting, from state to state with that individual. You would put that in a special needs trust, and their government benefits are not going to be negatively impacted. And that's extremely important when you have special needs children, because it's not something that's going to end once they're not minors anymore. So you want to care for them. And what I've had clients do sometimes is when they leave money in life insurance policies for special needs children, they set it up so that the beneficiary is a special needs trust for that child.
Okay.
It's also, you might say, well, the child is going to inherit the money, just to kind of put it out there. Like, yeah, they're going to get money, but depending on what their actual special need is, it could be very expensive. Like Medicaid or Medicare could be paying, $100,000 or $500,000 a year for whatever their condition is. So you don't want to, one, lose those benefits because now you have money, and two, you don't want to deplete those resources when the child is going to still, like she said, need that care forever. So that's kind of just a little bit more of an explanation about, because I see that sometimes too, even with my personal injury cases where the child is still hurt, and yeah, they might have gotten a six settlement or a 7-figure settlement, but that money's being put away into different things, and special needs trusts are being set up so that the child can continue to hold on to as much of that money for as long as possible, while the government is still taking care of the medical bills and things like that.
There are 2 questions that have come in, if I can ask them now, or at least
Absolutely.
you
No,
want
go ahead.
to do this slide first.
No, you can go ahead with the questions because the questions are most likely going to deal with what we just went over.
Okay.
So
So
it's
there's a
better.
question on Facebook. Life estate deed is in lieu of a TOD, which you don't have in Florida, correct?
Correct. We don't have the TOD deeds here in Florida. That is correct.
So for everyone else who's listening, can you just elaborate on that and explain a TOD?
I don't practice in any of the TOD states, so I can't specifically tell you how they work in those states. None of my 3 states have them. But a life estate deed is simply you own for your life, and then upon your passing, the property transfers automatically to whomever you have designated. I don't know how the TOD deeds work. I really don't.
Okay.
Josh, do you by any chance?
I don't, unfortunately.
Okay. And there's another question. If both persons have equal access to a bank account and the secondary is a beneficiary on the account, is it still necessary to do a trust?
If the only thing you have is that account, then no. If they both own it and they're a beneficiary, one of them's a beneficiary. Is that what they're saying?
That's what it says. But in either scenario, whether they jointly own it or the other person is the POD, if that's the only thing that you have is that one bank account, then I would say you still might need a trust, because a trust is going to address other issues like guardianship of children, of yourself if you're incapacitated. So it's going to do more than that. But that's kind of one of the bootleg estate plans, like thinking that you're covered. Like that covers one piece, but
It's just for that account.
Yeah, it's just if it was a pie, that's like one slice of pie, and you still got a whole pie left. So I would say you probably still do. You don't necessarily need a trust, but you do still need an estate plan. So it would depend on what else you got.
Correct. Was that all for the questions?
Yeah. Oh,
Okay.
Yeah.
Oh.
Yeah. For now.
Okay. And then we kind of touched on life insurance just a little bit. I don't want to get too much into it because that is not my world. And I know you guys have some great people that are going to be speaking on that. But how we use life insurance in estate planning is as a tool to replace or supplement income. When someone has passed away, obviously their income is not going to be coming into the home anymore. And so life insurance is a great way to make sure that your loved ones are financially taken care of without having to actually have a whole bunch of cash to leave behind, right? And there is something called an irrevocable life insurance trust where you would set it up. Now, the trust has to actually purchase the policy if you go that route. And that's a tax, that's for taxes. That's why you would do an irrevocable trust. And most of us don't need that anymore because as of right now, the estate tax exemption is $11.6 million. So it's not something that I'm seeing often, but if the estate tax number, the rate does come down again, because it goes up and down. It has actually completely disappeared in some years. Congress likes to play with it a lot. And so some people just go ahead and buy the insurance through the trust, through an irrevocable life insurance trust, because you can't predict what year you're going to pass away in. But if you already have the life insurance, then you can't go this route. But that's one of the reasons why life insurance is so valuable, primarily to replace income of the person who's passed away.
It's 11.6 million right now, and it does fluctuate, but a lot of people think in 2025 that it might drop drastically, and it would probably still be at least a couple million, which sounds like it's a lot, but depending on how much you've been putting into your retirement accounts, and if you own a house or two, like you'll be surprised. Like right now,
How quickly?
yeah, exactly, how quickly you could reach 2.5 million or 3 million. So, I mean, if that's a consideration that you have, that you're a couple mil, and you haven't set up your estate plan, you might want to do it now, and you see if you can reap some benefits that might not exist in the future, because you never know what's going to come down the pike.
All right. I mean, we already went through probate. Josh explained it very well. So I don't think I need to read this to everyone unless there are any questions specifically on probate. But I can talk to just the actual probate process. Basically, the first step of the probate process is you have to have a personal representative appointed. And if there is a will, you deposit it with the court, and the court is going to appoint the person who has been nominated as the personal representative. There are exceptions. The person who's been nominated may not have any interest in being that person, being the personal representative. And in that instance, you have to ask the court to allow someone else to do it. Also, if the personal representative that's named in the will has passed away, then obviously they're not going to be able to do it. As an aside, one thing that I always recommend with estate planning, anytime you're naming individuals, so human beings for anything, whether it's to be the trustee, whether it's to be the guardian or the personal representative, I always recommend that you name an alternative, because we are not immortal and life happens. So you should always have a backup person when you're naming individuals. Once the personal representative is appointed, they're responsible for creating an inventory of all of the individual who's passed away, all of their assets. And we actually have to file the inventory with the court. We have to send it to people that are called interested persons. We have to publish a notice to creditors, and it's simply a publication that goes in the local newspaper for whatever county the person passed away in that they were a resident of. We publish it. We have to publish it twice for 2 consecutive weeks. And then once from the first day of publication, you count 30 days you count 90 days from that first day of publication. And that is where the creditor period is cut off after that 90 days. And also your personal representative, they're going to be the ones who are going to, once creditors submit claims, the personal representative has to keep track of them, and with an attorney. Obviously, they're not doing this on their own. They're going to be doing with an attorney assisting them, because it's a lot. There's a priority for how payments are going to be made. Taxes obviously get paid first. And then also funeral expenses are at the top of priority as well. And then you go down, credit cards, whatever, those are kind of lower on the totem pole of debts that have to be paid out. And once all the debts are paid, then you're going to make the distributions to the beneficiaries, and you file a final accounting with the court, and you ask the court to release the personal representative, and we close the estate. As we said before, it shouldn't take more than a year. However, it can take more than a year depending on the value of the assets that are involved, and as well as the individuals that are involved. If you have some people that are litigious, or they believe that this is not a legit will, or there's another will, it can take a little bit longer than the 1 year to get through your probate. And then we kind of touched on this a few times, but we can just go over it again really quickly. Assets that go through probate are assets that you own solely in your name. And these are also going to be assets that they don't have, so it's not a contract. It's not like your insurance policy where you've named a beneficiary. It's not a bank account where you've named a beneficiary. It's not real estate where someone else has a survivorship interest, because one way you can own property is person A and person B with rights of survivorship, which means whoever passes away first, everything goes to the one who survives the two of them. You also, like we said before, the life estate deeds, that's another property that's not going to go through probate. And obviously anything owned by a trust, so anything that's been put in the trust before you pass away, will not have to go through probate. And that's pretty much all. That's it. That's your estate planning in a nutshell.
One more thing. So since you mentioned all the items that goes into the trust, what about businesses or even business assets? How is that?
That's a good one. That's a really good question. So if you own a business, your operating agreement is going to be extremely, extremely important. Your bylaws, because it depends on if it's an LLC versus a corporation. Your corporate documents, and you should have corporate documents. So let's start with that. If you own a company, you should have corporate documents that govern and control your company. And then the next thing is you should have what's called succession planning language in those documents. And that is something that an estate planning attorney can help you with. I do know there are also some corporate attorneys that have also are also able to do that. But you have language in here that specifically says if you pass away, who is going to take over ownership of the company? Are your family members allowed to buy your interest so that they can continue being members of the company? All of that stuff would be going into your corporate documents. You can also include it in your trust. I just like to do succession planning for the actual corporate document because you can have multiple corporations, multiple companies, and I prefer to keep it nice and simple. Each company has its rules.
Got it. Okay. So again, because some people came in at different parts and then people tuned in at different parts online, can the both of you speak about your firms and what you specialize in? And I know, Josh, you dropped your PDF, your free PDF. So also mention that as well.
Okay, sure. So my firm is called Josh Jones Law, PA, and we help people who are injured in serious car accidents and help people to plan for their futures with estate planning. So today, if you email me at info@joshjoneslaw.com, I'll send you a free PDF that discusses the 4 pillars of estate planning. And I'm also happy to meet with anyone who wants to meet or has additional questions at a later time. Thanks for having me today, Fabiola.
Thank you, Josh.
And again, my name is Alecia Daniel Hall. I am the owner of Genesis Law PA. I practice estate planning, probate, bankruptcy, and real estate law. I have quite a few freebies, including an estate planning 101 webinar where I go over all the stuff I've gone over here. There are some downloadables, including estate planning for newlyweds, the 6 P's of estate planning. And if you go onto my website, which is genesislawpa.com, you just go to the download section and you can download, I think I have 6 different estate planning freebies. I also have a bankruptcy freebie on there.
That's a good one you just brought up. I wish we would have known that when you mentioned this estate planning for newlyweds. Because imagine bringing in 2 different sets of assets, 2 different sets of families and beneficiaries, et cetera, and having to merge those things as well. And then what if, each of those persons have their own trust outside of the marriage prior to marriage, and now they're combining. So that's a good one. Someone else says, glad that you mentioned that, because I think that would be another big topic right there.
Yeah,
also, estate planning for after divorce is also important.
Oh, wow.
You can't accidentally disinherit your family if you have kids that from a prior marriage and you get married and have kids. So it's definitely.
Can you talk about that quickly? We still have some time.
I mean, basically, if your estate plan is not set up properly and you die before your new spouse, you had kids from a prior relationship where you were married before, and then you have kids, and then you get married to someone else. If you die before them and you don't have an estate plan, based on how the intestate laws work, you may not be leaving anything to your family anymore, because all of those things would now belong to your spouse, and then they would be leaving them to their family instead. So you would just lose rights to all your stuff.
Yeah, it actually, if you don't have a will in Florida, it's actually going to go 50% to your spouse and 50% to all of the other children. But think of a situation where you own property with your spouse, but you have children from a prior relationship and now you've passed away. Well, any property that you own with that spouse is going to that spouse. So if that's all you have, your children will receive nothing. And so it's extremely important for blended families, people with blended families, to have their estate plan in place, because a lot of people don't think about what can happen to their assets, because a lot of people just don't realize how intricate some of this stuff can be. There's a lot of assumptions that people make, and it's because we don't talk about it. We really don't talk about estate planning in our community. And so I'm so glad that we're doing this right now, because it's important for us to have these conversations and educate our community.
Yeah, someone else just mentioned, if it weren't for this segment, how would someone like herself know about this type of information or the proper attorney to better assist in these situations? So yeah, so there's not enough conversations about this. And unless you have access, some people are not even aware that this stuff exists to even know the type of questions, the right type of questions to ask an attorney, or even how to find an attorney to do, to provide these types of services. So these conversations cannot happen enough. We just don't talk about it enough, especially with COVID and, you know, how life has changed. Now is a very important time to really start talking about these topics.
Agreed.
Okay, well, if there are no more questions, I've been checking the online as well. There's, you know, comments and thank yous from the online. So hopefully, you know, support another Black business. So hopefully you all will be contacting attorneys Daniel Hall and Jones as well. So all their emails are provided. This is also on the Facebook page, on the MDEAT Facebook page. The link is provided, facebook.com/MDEAT-info. If you have, so are you all accepting new clients? Of course, money.
Yes.
Always.
Always.
We have to pay our bills.
Right. This is not like the doctor's office where they're like, we're not accepting new patients. Yes, thank you for asking that. They are accepting new clients. So obviously, you know, you're on your own accord, but we always advocate that you support our businesses. So feel free to reach out to them independently. And I'm going to post up the flyer. And if you have any more questions, you have like 60 more seconds. But in the meantime, I'll post up the flyer one more time because there are other topics. Alecia, you mentioned a few times life insurance. And so Pettis and Dawkins, Amy Dawkins and Eric Pettis, they are really good on this topic. You see the dates on here. So June 16th, which is this Wednesday, is Linda Harris, who's the Vice President of the Henderson Financial Group. She's amazing when it comes to building wealth and investing. She brings a wealth of knowledge and personal experience on this topic. So be sure to RSVP. All of these are free, by the way. That's June 16th. June 30th is real estate investment and wealth building. So I have Fred McClendon, who is a beast when it comes to investing and property acquisitions. And, you know, he's very passionate about doing this for our community. And financial advisor Karen Holloway from Northwestern Mutual, who does this for a living, financial planning. She'll be on June 30th. So it'll be an interesting dynamic to have the investor and the financial planner on the same topic. July 7th, building a real estate portfolio and cooperative economics. You know, we're definitely big advocates for us building up our communities, you know, slowing down the gentrification process and owning real estate. And then July 21 is Amy Dawkins and Eric Pettis with the Pettis and Dawkins Financial Group. So be sure to RSVP on these dates. Again, thank you both for joining and for providing a wealth of wisdom for our guests.
Thank you for having me.
And if there are any other questions
Thank
that
you.
come in after the fact, I'll be sure to send those your way. All right, everyone. Thank you and have a good evening.
Okay. Bye-bye. Thank you.
Bye.